Okay, I was under the impression that we were going to start with the original motion was not valid. You said it wasn't a motion. And so I was going to start with my
Sir, here's the thing.
actual motion.
It's like anybody else.
Mhm.
If we read something, we have to know what you're asking. So what you filed the first time, I had no idea.
I understand that.
So this is your motion now. I think you're asking something. The other guys have said, well, Amano, you don't have the authority to grant that.
Yeah.
So you have a chance to respond to their objections.
And that's where I said I was going to try to tell you I was going to start at, not at the actual non-motion.
Sure, go ahead.
Okay, and if it's okay, I kind of have to read some of this as I go along because I'm not a lawyer. So I'll start from the beginning. And I want to be clear that I'm asserting American law. That is slow. I'll go slower. And not making claims from a kingdom jurisdiction or from international law. And I think it's unfortunate that I see people trying to make the same motion using American laws, like for meets and bounds, for example, and it's getting relegated to a kingdom discussion that you have pretty much said you're not going to entertain. Yet some of these motions really are invoking American law, and as whether I think I'm occupied or not, whether I think I'm an American by force or not, I'm invoking American law, right? I just want to be clear before the responses come in, addressing irrelevant responses, by the way, addressing a kingdom issue or I'm trying to relegate my motion to something other than it is. So I'm invoking what I thought was what I know as American law. And in it, demanding an inventory of the so-called ceded lands containing the specific land and parcel TIO plans to sublease from UH, who leases those lands from the BLNR. Also, besides the inventory, a survey of these lands, also containing the specific land and parcel that TIO plans to sublease from UH. And these are, well, I'll keep going, sorry. Same parcel of land. And an official delegation of authority for those lands with the inventory and survey, complete. I'm asserting the law enforced, I believe, by American law, which I believe would show these proceedings are invalid because of lack of ownership, title, authority of this property under the same law, because no inventory nor survey is available delineating exactly the said lands. You folks, and I've heard you offer the Organic Act as or Supreme Court ruling that does offer the Organic Act as unclouded, which I'm paraphrasing, states that the title to the ceded lands, I'm paraphrasing, which states the Supreme Court decision that you're continuing to invoke here, states that the title to the so-called ceded lands, so-called trust, is unclouded. And that's a decision you seem to be going with to not entertain any more kingdom discussions, and that's not what this is. But still, under American law, I believe that you have to show title, ownership, title, and authority to the said property to some extent. And I do not think quoting, and I'm going to paraphrase again, sorry, that the cessation is held up by some kind of House resolution. It's belligerent, because a cessation, a ceded lands need a cessation, a treaty, and yet using a House resolution is not a substitution for a treaty. So that's a level, I think. You're using the evidence of the Supreme Court decision as your justification, but the two terms are incongruent, ceded and validating that with a House resolution. Let me read because I'm getting out of sorts. In the so-called state of Hawaii versus Kaulia, I think that's the same court case that TIO or HILO uses to refute my motion. The Supreme Court held that the criminal jurisdiction of the so-called state of Hawaii consists of all areas within the territorial boundaries of the state of Hawaii. The Supreme Court stated, pursuant, and I'm not a lawyer, I just trying my best to get this together, pursuant to HRS 701-106, 1993, the state's criminal jurisdiction encompasses all areas within the territorial boundaries of the state of Hawaii. State versus Jim 105 Hawaii and all that reference. The state charged Kaulia based on his conduct in Kona County, state of Hawaii. Thus, Kaulia is subject to the state's criminal.
Kalia? Is that what you said?
Sorry, yeah.
Did you say Kalia?
Kaulia.
Could you spell that?
Kaulia.
Oh, Kalia,
Sorry.
thank you.
Yeah, Kaulia. And I think I was at the state charged Kaulia based on his conduct in Kona County and state of Hawaii. Thus, Kaulia is subject to the state's criminal jurisdiction in this case, end quotes. Yeah. The official territorial boundaries of the so-called state of Hawaii are found in Article 15 of the state constitution and Section 2 of the Act of Admission. Neither law names the islands of Hawaii as within the territorial boundaries of the so-called state of Hawaii. Article 15, Constitution of the so-called state of Hawaii, on state boundaries. The state of Hawaii shall consist of all the islands together with their appurtenant reefs and territorial and archipelagic waters included in the territory of Hawaii on the date of enactment of this act, except the atoll known as Palmyra Island, together with its appurtenant reefs and territorial waters. But said state shall not be deemed to include Johnston Island, Sand Island, which is offshore from Johnston Island, or Kingman Reef, together with their appurtenant reefs and territorial waters. Section 2, Act of Admission, so-called State of Hawaii, 73, and I do not know what that stands for. The state of Hawaii shall consist of all the islands, together with their appurtenant reefs and territorial waters, now included in the territory of Hawaii, except the atoll known as Palmyra Island, together with its appurtenant reefs, so it's almost the same thing, yeah, and territorial waters, but said state shall not be deemed to include Johnston Island, Sand Island, offshore from the Johnston Island, or Kingman Reef, together with the appurtenant reefs and territorial waters. In order to prove that the island of Hawaii is within the so-called state of Hawaii, it must be proven that the island of Hawaii is included in the territory of Hawaii. Thus, you must look to Section 2 of the Organic Act to determine whether the island of Hawaii is within the territory of Hawaii. The Organic Act states in its Section 2 that only the islands acquired by the joint resolution annexing the Hawaiian Islands are within the territory of Hawaii. That the islands acquired by the United States of America under an act of Congress entitled Joint Resolution to Provide for Annexing the Hawaiian Islands to the United States, approved July 7, 1898, shall be known as the territory of Hawaii. The joint resolution did not acquire any of the Hawaiian Islands. It had no power to acquire the territory. This is not a cessation again, of a foreign sovereign nation, such as the Kingdom of Hawaii. If that were the case, and this all leads up to the American title and the American law I'm trying to invoke. If that were the case, then the Kingdom of Hawaii could, by an act of its own legislature, acquire the United States, make their own House resolution, This is not an invoking of kingdom law, but American law. I want to keep saying that. The joint resolution did not acquire the island of Hawaii. Thus, the island of Hawaii is not within the so-called state of Hawaii. This is the law according to the state constitution and the laws of the United States. that admitted Hawaii as a state. And from what I understand, you are bound to follow these laws. Therefore, I believe you have no jurisdiction according to American law over Mauna Kea, as it is outside of the state of Hawaii and outside of your jurisdiction. Hawaii courts under Section 202B of the Hawaii Revised. Okay, stopping. Hawaii courts under Section 202B. My mouth is dry, that's why. Of the Hawaii.
Mr. Kealoha, may I ask you this? You're saying Mauna Kea is not part of the state of Hawaii?
Not just Mauna Kea, but the lands.
All the
of
land
Hawaii.
in the state of Hawaii is not part of the state of Hawaii?
Yes, because there's no cessation.
Okay, I understand.
Yeah. Hawaii court must take judicial notice of Section 2 of the Organic Act and the Act of Admission, such as mandatory. The court has no discretion. The court must follow the clear and plain meaning of those laws of the United States, and the burden is on the hearing body asserting to have jurisdiction over these lands to prove the existence of jurisdiction. This is the state law and law of the United States, I believe. And we quoted CCAB versus Island Airlines. And I'm going to just read off these numbers, okay? 352F, I guess, dot 2D, 735, there's a comma, 741, and in parentheses, from the Ninth Circuit Court in 1965. And we quote a line from that decision. The burden of proof is thus logically and emphatically placed upon the claimant state, end quotes. And I'll just leave the last line out because it has nothing to do with this here. Do I continue with the, Doc 189 if it's part of this?
It's up to you, but I'm
Okay.
going to give the other guys an opportunity also to speak, and then, of course, you'll have the last word.
Like, I've already responded to their opposition. Can I
Yes,
can I
you
go
have.
through that?
You don't need to reread it. I have read your,
I don't
Submissions.
feel I've conveyed exactly about Quo Warranto. And I'm trying to get there, but I'm a little confused. So if you give me some time,
okay?
real quick. Yeah, I think I'm just going to go through it. I'm not going to read everything. TIO claims in their opposition that the motion is not proper before the hearings officer. And the motion is a demand of jurisdiction under Article 4. So I didn't get to say that earlier. And their claim is that I must make it in a circuit court. And I don't feel that TIO, it's misspelled here, it says TMI. Sorry, it's hard, you know? Does not justify, no offense, I'm sorry, does not justify in their opposing statement that the order must be issued in the name of the state by a circuit court. It says it does, but it doesn't say it must, it doesn't use that language. Neither does the law cited therein state that the order must be attained by petition addressed to the circuit court. I think I just repeated myself. As applied in the judgment against the move to invalidate the application due to the change of name, because they were TMT Corp or something before, and entity of the applicant, as precedents, I asked the justification that was used, namely that because must and required are not written, that it must also not mean that it can't be done, And I plead that the hearing officer is compelled to fairly apply the same justification here, or reverse the decision against the motion to invalidate the application process immediately, and end this charade, I call it. As the Supreme Court stated, and I paraphrase here, in the remanding of the permit, the exact reason we are here, to be just, something must be seen as just. And it is not just to cite that just because it is not written doesn't mean it can't be done for one motion and not apply it to all, specifically to this motion. That's the best jurisdiction, prudence, whatever they call that I have. If the motion is not the right motion that I'm asking for, and there is another appropriate motion, I wanted to reserve the right to access the so-called user-friendly process and work that out, because I'm not a lawyer. Again, I'm in a room full of lawyers told that.
So in my simple understanding of Quo Warranto, my simple understanding is that that's a mechanism by which you're saying to the court or the state or whatever, do what you're supposed to do. That's essentially what it is. And it has a common law basis, meaning it existed before there were statutes. So they would be, but it would have to be done in court, okay, not in a contested case hearing like this one. So the state of Hawaii, if you recall reading, I think it might have been Mr. Ng's memo or someone's memo, has codified the Quo Warranto. In other words, it's put it into the laws, and it needs to be filed in circuit court. So that's why they're objecting to your motion. I don't have the authority to grant that. That's the bottom line. I can't do it.
You can't show me jurisdiction, you mean?
I can't give you the relief I think you're seeking.
The relief I'm seeking, I think I spelled out in the clarification of my motion, which is, let me just be exact, sorry. An inventory of the so-called ceded lands containing the specific land and parcel the TIO plans to sublease from UH, who leases said lands from the BLNR. That's one. A survey of these lands, also containing the specific land and parcel the TIO plans to sublease from UH, who in turn leases from the BLNR. And after that, the official delegation of authority that I guess would come from the BLNR if they had those first two.
My understanding is the law doesn't give me the authority to give you that relief. That's my understanding, but...
Okay. I think it's problematic if you can't show us the lands that they plan to build on, that you're claiming authority over to judge this, that's the right word, to make a determination for this hearing. You can't show that that land actually is in the authority of your presiding. That's a little problematic. Don't you think?
I hear you.
Yeah. And that's, I hope, would be taken in the perspective of American law so it doesn't get thrown off the table. I mean.
Understood. If you don't mind, maybe we can hear from Mr. Ng and then the university, and then I'll come back to you again.
Sure.
All right? So if,
Thank you.
Mr. Ng, or, sorry, Mr. Shinyama.
Thank you, Your Honor. Rosh Shinyama for TIO.
Thank you.
We would essentially stand on our opposition, which is doc number 184. But I would like to stress one point, and you guys have already touched upon it, that you are correct that the motion seeking relief of Quo Warranto is not properly before you. And quite frankly, notwithstanding what Mr. Kealoha just stated, that's not in dispute. Because if you take a look at Mr. Kealoha's own affidavit to his motion, and it actually starts on page 8, Your Honor, he quotes a section, some type of law about Quo Warranto. I'm not exactly sure where he gets it from because he does not provide us any type of cite. But if you take a look at paragraph C, it says actions for Quo Warranto under this section must be commenced in the circuit court. So that's his own words, Your Honor. That's his own affidavit that specifically states that his own motion should be properly before the circuit court, and it's not properly before Your Honor. Nothing further.
Thank you, Mr. Shinyama. And the UH joined in the objection?
Joined in the objection, Your Honor, and I would add, I mean, what, from what Mr. Killo has actually explained in his Quo Warranto motion, it really is a rehashing of Mrs. Vincente's original motion for dismissal on the basis of lack of jurisdiction, and I think it should be treated the same way.
All right, thank you. And Mr. Kealoha, if you wish to add anything else? Okay, hold on. Pardon me, you filed something, Mr. Fergerstrom?
Yes, I did.
What document number was that?
Oh, 203.
No, his.
203.
No, 203 is
Yes.
filed by TIO.
Oh, shucks.
Is that 206?
206, yeah, sorry.
Okay, I'm sorry, Mr. Ferguson, it didn't make it to my grid. So if you would like to speak, go ahead.
Good afternoon again. Harry Ferguson. I did an opposition to TMT International Observatory's opposition
Yes.
to Kealoha's motion to invoking Quo Warranto. I started this off in a very, very careful way because what we have here is a confusion of whose words are what words or how we rely on these words. So I used the what's the word? The descriptions, the definitions found in Black's Law Dictionary, edition 5. Okay, and Quo Warranto in that respect says to inquire by what authority. It directly relates to the two words, the word jurisdiction, of which there are two types, a de jure and de facto.
I'm interested in hearing why it should be before me and not in circuit court.
I'm not going to argue that part yet. I'm going to need to build it up so you can understand. I'm not going to challenge you on that. I'm saying that because this is to set record, because there, along with this objection from TIO and University of Hawaii, is all these allegations that they are the law of the state of Hawaii, which I don't agree with, and neither does this stuff that I'm reading. That's why I'd like to have it on record.
Okay, but let's stick to the motion invoking Quo Warranto and it having to be in circuit court, which is the big problem.
It is a big problem for you to decide upon. It is not a big problem for you to take information based on it, because the fact that Quo Warranto has been raised in this case is something that you should be able to take judicial notice of and bring it back to the board as a feature that is very problematic in this case. Because, of course, if you don't have an authority to make these decisions that you're set with, then it's just a very problematic thing until we determine whether or not there is a legal jurisdiction that the state of Hawaii claims. Because quite frankly, as I put in my motion, or my response, is that the entire process well, let me go back. Once challenged, jurisdiction cannot be assumed. It must be proven to exist. And so what's happened here is whether it's the University of Hawaii, TMT, TIO, or PUEO, or any other John Doe that you're talking about here, is relying upon the assumption that the United States and its political subdivision, the state of Hawaii, is somehow not subject to the law, even their own laws, like the U.S. Constitution. That their entire position is based on their own self-projected self-authority. Their entire line of thinking and projection is predicated on the idea that a joint resolution of the United States Congress, i.e. the Newlands Resolution, has any lawful effect outside of the continental borders of the United States, and that such a resolution has the power to annex a foreign country, such as the Hawaiian Kingdom. Treaties are the supreme law of the land. Without a treaty of annexation, there is no... Okay, thank you. Without a treaty of annexation, there is no lawful means in which the United States or its political subdivisions can assert their jurisdiction in the Hawaiian Kingdom. That authority is precisely what Quo Warranto challenges. It basically asks, who are you and by what authority? And so it cannot just be assumed. And what I'm saying is, this is for the matter of setting into the process, something that may have to come up in a circuit court. I certainly understand that. But because of these other correlating opinions that are being made here, that because of their thought that the Kalia and stuff like these are all state within state type of stuff, or the state questioning by the federal government. You're asking yourself, or they're asking themselves, am I right? Of course they're not going to say they're not. That's why you have such a thing as Quo Warranto. It's not something that's new. This is a very, very old, extraordinary writ to challenge by who, by what authority you claim to be this person. And so, and this is why it's so important that at least the information be laid in this process right now. Whether you, I agree, you don't have the jurisdiction to make a decision on that, but you do have the ability to take it into record. And that's what I'm trying to do, because there's a lot of assumptions being made on the fact that Quo Warranto cannot even be asked until we get to a court. Like, there's no record that can be made, but they can make the record contrary. And that's what they proceeded to do.
All right, thank you, Mr. Bergstrom.
Thank you.
Just one second. So as far as my affidavit not being referenced, I want to correct that comment, because I do quote the U.S. Constitution. It says so right here. Oh, but above it, but Article 4, Section 4.
I'm sorry, the force,
Sorry.
what did you just say? I'm sorry.
I thought the comment was that it had no references in my affidavit.
No, you said you were quoting the U.S. Constitution?
I was quoting the U.S. Constitution, Article 4, Section 4.
Oh, thank you.
And also again later, Article 1, Section 1 and Section 2, Clause 1. The Quo Warranto does the Hawaii statutes that they quote requiring circuit court submission eliminate common law right to bring the action? That's what I like to offer against that. And when somebody is characterizing me, telling me, saying to everybody else that in my own words I said this, or in my own words I said that, the truth is, you know, I'm consulting people who are educated in the legal realm. I just can't afford to bring them up here. So I'd like to point that out to this user-friendly system, because we're subjugated. I don't think the Hawaii state statutes, so-called state statutes, eliminates common law right, if that makes any difference here for you.
All right. Thank you, Mr. Kealoha.
Thank you very much.
I'm going to deny Mr. Kealoha's motion for Quo Warranto, inasmuch as I do not have the authority to grant the relief he is seeking under that legal mechanism. I'll prepare the order. Rather than repeat all the motions that are remaining, I'll try to put it into a minute order following today, so that you know what's coming up on the 29th. But I'd like to, at this point, adjourn the hearing and convene the third pre-hearing conference.